Good afternoon, everyone. My name is Lluc Cerda. I'm a managing partner of the Calgary office of Samfiru Tumarkin, and its Western Canada practice lead. Thank you for joining me for this year's first show of employment law questions and answers, or at least the first show for me. So happy to be here and to start a new year with you guys, getting as many of the questions that you have about your employment rights answered in the next half hour. Feel free to put your questions into the chat. I'll get to as many of them as I can today. While we do that, I also wanted to discuss something that came out of the Toronto Post, the Toronto Sun, actually, earlier today, that my good colleague and friend John Pincus was commenting on. The story of a radio DJ in Philadelphia who had been terminated for his stand-up routine. Which the radio station felt had inflammatory passages, and so he was terminated on a for-cause basis. It seems that he was unionized and took his matter to file the grievance, and the grievance arbitrator sided with him and decided that he was entitled to have his job back. Now, that's not usually something we can get when you're not unionized, that you get reinstated into your job if there's not enough for-cause material to warrant your for-cause termination. But it kind of goes to show that, the reason I bring it up is to talk a little bit about off-duty conduct. So it does happen quite often that I have people calling me saying, Luke, I've been terminated for something I said on Facebook, on Twitter, whatever it is. Or in this case, for my stand-up routine. Is that allowed? Don't I have the right to free expression? So you do have a right to free expression. Freedom of speech is a protected right under the Charter in Canada, and this was a U.S. Situation. Of course, they have right to free speech as well, but it didn't really turn on free speech. So these matters don't often really turn on free speech. It's not that you don't have free speech. That said, your employer can terminate you for your off-duty conduct in certain circumstances. My recommendation to anyone who has these kinds of questions that may share, any types of political or other types of posts online or anything like that, the first rule of thumb is, in your handle, when for instance, on Twitter, you might say, for instance, I would say I'm a lawyer, I'm an employment lawyer. But you would be wise to make sure that you don't mention who your employer is. So you wouldn't say, well, I'm a lawyer at Samfiru Tumarkin. Or if you do, realize that you're identifying yourself with your company, and you might not want to post things that might be more controversial than need be, because if your employer, for instance, doesn't agree with your position, that could potentially cause friction at work. And if your position is kind of so out of balance of what they find acceptable, you might face discipline. All right. This is especially so if you have a position where you act as the face of the company. All right. If you are someone that is closely identified with your company, you have to be extra careful of what you say on social media or anywhere that can, be seen by a lot of people. It can be also that, might not necessarily have a client-facing or a public-facing role. You might still, it might still be an issue. You can imagine a scenario of a driving instructor that's charged with a DUI offense. All right. So basically, the link between being a driving instructor and driving while intoxicated is really kind of breaks down your employer's faith that you can do your job. So that's an off-duty conduct, but that can have an impact. So I've been talking about posts. Posts have been in the media a lot recently. What can you say? What shouldn't you say online? But it's any off-duty conduct that can really lead to some form of discipline. So there are steps you can take to mitigate your risk. If you're wanting to participate in the conversations and debates that we're having as a society. Like not identifying with, that you work for a certain company, not being in a public-facing role. At the same time, in this particular case, this gentleman, this comedian/radio host, was reinstated because the arbitrator kind of disagreed that some of this stuff was inflammatory. So it may be a bit overly cautious of the employer to see controversy where maybe there was none. Now, unfortunately, the article that I read about this and that my colleague John Pincus was commenting on didn't include the excerpts of what exactly was said. What were these kind of racy jokes that were being shared? So it's hard for me to say, oh, this crosses the line or this doesn't cross the line or someone overreacted or didn't, right? But essentially, it comes down to, it becomes a bit of a sniff test, right? We know what's outrageous, what's racist, what's misogynistic. We kind of know that. So and you're dealing with potentially a judge at the end of the line that's a part of this community, just like everybody else, and will uphold community standards to a certain extent. All at the same time, realizing that, and oftentimes when I'm dealing with just cause, I don't talk about my client didn't do anything wrong. Instead, what I will say is whatever my client did does not warrant him being terminated or her being terminated for cause. There were other forms of discipline that were available. And in this case, the arbitrator substituted lesser forms of discipline. The arbitrator required that this radio DJ delete the stand-up comedy routine from his online posts, from his Facebook, from his social media posts, and delete further, comments that he had made after he was terminated. So an arbitrator can do that, replace a for-cause termination with lesser forms of discipline. In the non-unionized context, if the judge finds that there is no just cause, then you just get your severance. You don't get your job back with different discipline or anything like that. You get your severance. That's the difference between unionized and non-unionized. And finally, to finish off this little segment, what I can tell you is that the law of just cause, whether something amounts to just cause, is very, very similar in the unionized context as the non-unionized context. I'm always using unionized decisions on just cause when I'm making arguments about a just cause termination in a non-unionized setting. All right, well, we do have some questions that rolled in during that time, so let me get to them. So the first question comes from Ash B. Ash is asking, hello, if you work in the service industry, is your employer allowed to take a share of tips? So generally that is not allowed, all right? So there's a lot of employment standards legislation. It kind of depends what province you're working out of, Ash, but I know that, for instance, Ontario made some recent amendments to the Employment Standards Act to address tip sharing, and that it shouldn't be shared with people that are not the frontline staff, the people actually serving. So, for instance, the manager, if the manager is not also helping out in that. So, no, that isn't allowed. At least not in Ontario. It depends on the province that you're in. I'd have to go and delve into their employment statutes, but I can talk to you about Ontario, Alberta, and BC here today. And I'm pretty sure that Ontario just clarified that that's not allowed. That's a form of wage theft, essentially. We have another question coming in from Wayne Higby. Wayne is asking, I had a feeling I was going to get terminated, but I went on short-term disability instead. I don't see the question you have for us here, Wayne. Maybe you thought you had sent in another post that I'm not seeing here. But that often happens. I have clients, who are going through a very toxic or very stressful period at work, and it seems that the employer is kind of setting them up to terminate them, and it becomes too much. It really does. And my advice to them is, to these employees is, speak to your doctor, right? I mean, that's first and fundamental, is that you take care of your health first. You're no good to yourself. You're no good to anyone when you're just beside yourself with stress and grief and emotions, right? You need to take the time to take care of yourself. So if you are being overwhelmed with these kinds of stressors and emotions and anxiety because of a situation that's going to work, and feel free, absolutely, reach out to me, reach out to my colleagues. We want to help, but part of it is also making sure that you're getting the medical care that you need. And sometimes by not being in that workplace, by not having that stressor, we can work in the background and get you out of there with a severance package in a way that's not as aggravating. All right. So you had it there on the screen. Our The best way to contact us, you can reach us at our website, employmentlawyer.ca. That's employmentlawyer.ca. So we have another question coming in from YouTube from Ralph, which is asking, what is the difference between a contractor and a subcontractor? So I guess that would kind of depend, Ralph, on what area of law you're talking about. So it's contractor / subcontractor may be relevant to something in the area of construction law. In the area of employment law, both kind of mean the same thing, all right? So a contractor is someone who's not an employee, all right? A contractor would be someone, for instance, who instead of being paid an hourly wage, invoices the client and charges GST. The reason it becomes relevant in employment law is that a contractor doesn't benefit from the same rights that an employee might have. For instance, the right to severance, the right to EI might also be affected. They don't do their taxes the same way, right? The employer will not take off tax at source, won't pay CPP, things like that. A contractor is usually not entitled to vacation pay or to statutory holiday pay or even overtime pay. So because of all these rights that the contractor doesn't have, a lot of employers are often interested in classifying someone who should, in the eyes of the law, be viewed as an employee and who should have all those protections the employee has. An employer might be tempted to instead have that person agree to be a contractor for various reasons, all right? But the reason it comes up in employment law is that you have the right to have a judge decide whether your working relationship with your employer was more akin to an employee relationship, or was it more akin to a contractor relationship? And if you were labeled or misclassified as a contractor when in fact you were an employee, that might open up a lot of avenues for you to receive additional compensation. Firstly, you might be entitled to severance. If you kept track of your hours, you might find that you can also claim for overtime, for vacation pay, for statutory holiday pay. This might entitle you to claim EI, things of that nature. So if you are someone who thinks, well, I've just been terminated, they told me I'm not owed any severance because I was a contractor, speak to us. It might be that you were misclassified. It happens a lot, quite a bit, and that you were in fact, in the eyes of the law, an employee, and you're in fact entitled to severance. So definitely something that if that's something that's come up for you, reach out to us. We can help. So Chrissy is our next question. Chrissy is asking, can an employer refuse a return to work after a parental leave? So there's two kinds of situation where that happens, Chrissy. So I just want to make sure we're on the same page. Say you tell your employer, my parental leave was over January 5th. I'd like to come back on January 8th. And you tell them this on January 4th. They might say, whoa, we're not ready for you. Give us a couple of weeks. That makes a little bit of sense. You really want to make sure that the employer can plan for your return. If, on the other hand, you write to your employer saying, listen, I'm ready to return in a month, my parental leave will be over, and your employer, for whatever reason, says, we can't return you, well, what exactly are they saying? What happens to your jobs? And so generally, an employer can't refuse to take you back to your job if your position still exists. All right. So if however, during your parental leave, you worked in, let's say, the accounts receivable department, and that accounts receivable department got closed, shut down, and outsourced to a third party, and everyone in the accounts receivable department was terminated. And when you come back from maternity leave, you're terminated right away, again, because there's no account receivable department. That's legal because that had nothing to do with your parental leave. The reason you lost your job is because they closed down the department. Everybody got laid off. They just wait till you came back to terminate you, all right? So they can't refuse to take you back. Your employer can't refuse to take you back for having gone on a maternity leave, and it is a job protected leave, so they have to hold your job for you. They can put in someone in there temporarily. We all know of, parental leave, maternity leave replacements contracts, that's very frequent, and that's how it's supposed to be done, so that when that person is ready to return, there's a job for them there. So if your employer is telling you, no job for you, we actually hired someone to replace you, and we like that person a lot better than we liked you, so we're not going to give you your job back. So even if that's the case, you'd be entitled to severance. I mean, you'd be owed severance for that. But in fact, you would also have certain rights under employment standards legislation and under human rights legislation, which may entitle you to get your job back. On top of severance, you'll get your job back. They'll be forced to take you back. So that's an option that's available to you. So if that's something that's happening to you, Chrissy, if you're thinking of coming back from parental leave and you're getting the runaround, reach out to us. We may be able to help get this sorted for you quite quickly. And we're at employmentlawyer.ca. Sometimes it's just telling the employer, listen, Chrissy's got a lawyer. She knows what her rights are. Stop, giving her the runaround, and let's get her back to work so she can earn her salary. We have a question coming in from YouTube from Asharif. I hope I'm pronouncing that correctly. I was let go from my position after 23 years. My employer first placed me on a suspension over someone else's mistake. Do I have a case? So, Asharif, it seems that you were terminated for cause. Let me know if that's the case, okay? So essentially, an employer can terminate you for almost any reason on a without cause basis, okay? So not a reason like Chrissy's situation. You can't terminate someone for going on a parental leave. You can't terminate someone for having a disability. You can't terminate someone for instance, making sure that their paycheck is correct or trying to enforce any rights they have under employment standards legislation. You can't do that. Those people can be reinstated. But just about any other reason, you can be terminated for any other reason. You wore a blue shirt to work today. We have a strict no blue shirt policy, for instance. Here's your termination letter. They can do that so long as they pay you your proper severance, okay? But what a lot of employers do, they decide, I don't want to get out of paying someone who's been with me for 23 years the kind of severance that they're entitled to. So I'm going to claim that I have just cause to terminate them. And that allows me to say, well, I'm terminating you because you did something wrong that's so serious that I can claim that I have just cause to terminate you. And therefore, I don't even owe you severance. It's magic. Your right to severance disappears, right? It's not that easy, Asher. So basically, you have the right to have a judge decide whether the employer had cause to terminate you. And precisely what you're describing to me would not rise to the level of cause. I don't have all the details, but I have enough details to think that you should reach out to us because you may very well have a case and may be entitled to substantial severance. If what you're being blamed for you didn't even do, and that's the reason they terminated you, looks to me, if there's nothing else to the story, that you have a pretty strong case. If you're based in Alberta, Ontario, or BC, that you have a pretty strong case that your employer doesn't have cause to terminate you and you're owed severance. Now, you have a lot of years of service here, Ashraf. I'll let you know that the maximum you can get in these provinces that I mentioned in terms of severance is usually going to be 24 months of severance. So that's still 2 years of salary, and you seem like you would be a good candidate to have something in that range of 24 months. If you want to make sure, or any of you listening, like severance, fine, I'm entitled to severance, but how much are we talking about? We have a great online calculator where you can calculate your own severance, see how much you might be entitled to. So it's at severancepaycalculator.ca. And you can also get to it by pocketemploymentlawyer.ca. You go to those websites, we'll ask you just 4 basic questions, and once you have answered those questions, we can give you an estimate of what kind of severance you might be entitled to in months and amount of dollars. It's all, just free information that we give to the public. So there's no requirement that you pay a fee or book a consultation or anything like that. It's just there for you to know. So even if you haven't been terminated, you're wondering, well, I don't know what could happen. Maybe I'd like to know what I might be entitled to if something does happen down the road. I'm presented to with a severance package from my employer. I want to know, is this a good one or not? pocketemploymentlawyer.ca. It's up there on the screen. It takes probably 30 seconds to get an estimate of what your severance entitlements might be. We have another question coming in from Paulo Estevez. Paulo asks, the question, does the employer have to cover the cost of personal tools that was stolen by thieves that broke into the work site? That's a good question, actually. I think it's not an employment law question, though, Paulo. It might have to do with insurance, okay? So I would talk to your employer about seeing if you can make a claim through their insurance for your losses, or whether you can make a claim through your own personal insurance, whether you have insurance through your business or through your home insurance or something like that, to make a claim for that insurance. I don't. This is actually the first time that question's come up to me, and I don't recall seeing that being an issue in any of the many cases I've read on employment law. But of course, we all know that if a thief breaks into your house and steals your tools or steals, your clothing or anything like that, usually what you do is you go to the insurance with that, right? So before you go into thinking, oh, maybe I can sue my employer for my lost tools, I don't know how much we're talking about here in terms of value. It might be the easiest route to see if the insurance will take that claim for you. All right. It could be that the employer has an insurance plan that covers even the tools of its staff and its employees. And if that's not the case, maybe you have something through your home insurance to cover these tools, even though you were on a work site. So that's probably the kind of more practical rather than legal response, but I don't know that there would necessarily be a claim there against your employer unless you can somehow show that they were somehow involved or negligent. They left the gate open or something, maybe, or they assisted the robber, I don't know if there's necessarily a claim there against your employer, is my answer. I have a question here from Anna Gila. Anna is asking, how can I contact you live in Calgary? So this is my live event. Usually I'll have consultations as well with clients, throughout the week that want to speak to me about their employment rights, about going after more severance. You can make an appointment. You can contact us at employmentlawyer.ca. Just leave your contact information. We'll reach back out to you and set up a time where we can speak with you about your employment law concerns. So that's the best way to do it, employmentlawyer.ca. All right, Chrissy is following up here. Chrissy, you'll recall, was having trouble returning to work from a parental leave. So what Chrissy is saying is that the employer is saying they have enough staff for the volume of work. Are they allowed to extend my leave time? I think they do want to keep my replacement. So no, they're not allowed to extend your leave time, Chrissy. I think you do have a claim here. Three claims, really. You would have a claim for severance. I think that if they're not willing to take you back, they're constructively dismissing you, even if they haven't terminated you officially. You would have a claim under human rights. This is a job-protected leave, and terminating someone upon their return of medical leave, even though the job is still there, returning from parental leave, may very well amount to discrimination under human rights legislation. And your parental leave was also a job-protected leave under employment standards. So definitely, they're in a lot of trouble if they don't back down. So if that's something that you don't want to accept, you don't want to wait indefinitely till they call you back, then I would say get in touch with us. We'd be happy to help you with this one. Again, if you didn't jot it down earlier, it's employmentlawyer.ca. You have it up there on the screen. We have a question coming in from Glenn. Glenn is asking a great question. Is severance pay the same amount given for years of service, age, position, right across Canada? Well, that's a good question, actually. So I'll just preface this by explaining that severance, as Glenn has pointed out, is not just based on your years of service, all right? So you can have two 15-year employees, both go to court on the same day, even could see the same judge, and the judge will not necessarily give each employee the same amount of severance because there are other factors that come into play. The employee's age. For instance, judges typically find that employees that are over 50 are entitled to more severance because judges understand it takes longer for an employee who's 50 and up to find new work compared to a younger employee. So age is important. The position that you have, right? Of course, if you're a executive vice president of research and development, you would likely get more severance than someone who's a laborer. It's not necessarily the fairest, but again, judges are like, well, it's going to be very hard for that person, the executive vice president, to find a comparable position to the one they had. And so I have to account for that when I'm figuring out how much severance do they need to cover how much time it might reasonably take them to find a new job. The availability of similar work. So for instance, there was a case that just came out, a great case. This person worked for an IT company and a very senior role, had years of experience and all of that, but was working for one of this IT company's offices in a remote community. I believe it was Trenton, Ontario. And so realistically, for this person to find a new job that was comparable in Trenton, Ontario was not realistic. In fact, they would probably have to relocate maybe to Toronto or Ottawa. And maybe that's not realistic because this gentleman was also, with his years of service, had several, was an older worker as well, right? So the judges, this actually went up to the Court of Appeal, agreed with the trial judge that, this also is a factor to consider in giving a longer notice period. So what did I say? Age, length of service, availability of similar work, and the type of position that you have. But again, is it the same across Canada? It's essentially the same. It's not exactly the same. All right. So there are trends in different provinces. And when I say across Canada, really, I'm only qualified to speak about Ontario, BC, and Alberta. So, if you're in, Quebec or you're in Nova Scotia, you'd have to check with a lawyer over there. They're essentially the same, but they can be different. All right. They can be different for sure. So it's not that one province will give you 12 months and the other province will give you 6, or judges in those provinces will make it half of what another judge might do. It's not that extreme, but it can vary from 1 month, 2 months, maybe even 3 months from province to province based on the 4 factors that we talked about. So it can vary a bit. Yeah, there are certain trends. There are provinces that might be renowned for being more generous. Ontario might be more generous than Alberta, for instance. That's something that we've noticed here at the firm, but still, that's it's not so great that it makes we're talking about apples and oranges either. All right, so I'll put that out there. We have a question from Reddit from Trick. Trick is asking, I was placed on a temporary layoff. Can I find work while laid off? Do I need to give notice to my old employer as stated in my agreement if I am not working? So to answer the second question, do you have to give notice? I would have to see your agreement. Okay, so I don't have that in front of me, so I can't really say. Absence an agreement, I personally don't think you have any obligation to tell your employer that you found work while you're on layoff. All right. What's important is that you will have to be recalled at some point by your employer. Otherwise, you're owed a severance package. They can't keep you on layoff forever. Okay. So what you need to understand is when you're recalled to work, Trick, from the job you're being laid off, you're going to have to make a decision. Do you want to go back to your old job, or do you want to keep this new job? If you keep the new job and don't go back to your old job, you will be found to have abandoned your old job. All right. And abandoning a job is like quitting a job. And what that means is that you're not entitled to severance. Okay. So if this is the first time as well, Trick, that you've been laid off, and if there's no clause in that agreement of yours that allows your employer to lay you off, it can be that you can treat the layoff as a termination, as a constructive dismissal. So if that's something where you want to say, well, I don't want to go back, I don't want to be laid off, I would rather go after my severance, then I would say reach out to us, because we can help you get a severance package if you've been laid off. All right. So again, it's up there on the screen, employmentlawyer.ca. That's the last question I have in my feed, and conveniently that gets us to the end of the half hour. I'd like to thank you all for your great questions today. Really interesting stuff. I'm glad that we were able to discuss this. We have shows coming up very shortly. We have another employment law Q&A coming this Thursday with my colleague Jeremy Herman, based out of Ontario. So he'll be answering your questions at 2 p.m. Eastern Time. If there's anything that came up that I wasn't able to touch on, Jeremy is definitely can field your questions. So feel free to jump in onto that live stream. Once again, my name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. I'm the West Coast employment law practice leader. It's been a great pleasure speaking with you guys today, and all of you. And we hope to see you soon. Thank you.